And what it is that I want to talk to you about how to handle yourself, what you should be doing when you are out at counsel table with your attorney, and your attorney is involved in the hearing or the trial, either talking to the judge or questioning an attorney or questioning a witness, or just simply listening to testimony. So that'll be the first thing that I'll cover, is what you need to be doing during that time. And then the second thing that I'll be covering is when you're on the stand, either getting questioned by your attorney or going through cross-examination from the other attorney, which can be very difficult to go through. If you're going through cross-examination with somebody who knows what they're doing, it's not good, pleasant. It just isn't. So we're going to touch on that too. Okay. So the first part is when you're sitting at counsel table with your attorney, and if you don't have an attorney, you can use some of this too, especially like if it's the other side's witness that's testifying. Okay. But this is what you want to be doing. A couple things you definitely do not want to do is you do not want to draw attention to yourself during that time. Okay. That is the time for either the judge to be speaking or the attorney to be speaking or the other witness to be speaking. So you definitely don't want to go through and do anything that's going to draw attention to you during that time. That's number one. And number two is you do not want to do anything that is going to prevent your attorney from paying attention. Okay. For me as a lawyer, whenever I'm in a case, and whenever I'm in a trial and I'm trying to listen to the testimony, the last thing that I want, and I can almost guarantee you that all your attorneys are going to agree with this, the last thing that I want is for my client to be interrupting the testimony that I'm trying to pay attention to, because I'm trying to get all of this information to make sure that I can defend him or her appropriately and most effectively. Okay. Now, I say that in an understanding way because I get it. I get why people do that. It's a very emotional situation, and you want to leave no stone unturned. You want to jump on everything that's said. But your attorney has a job to do. And if he or she is doing their job, they need to make sure that they're paying attention so that they can be, like what I would do is quickly be thinking of all angles of everything that comes out of someone's mouth. Like, okay, how do I deal with that? How would I deal with that? How do I deal with that? The last thing you want is someone to be chirping in your ear, like, oh, hey, that's messed up, or that's bullshit, or whatever. It's not effective, and it's not conducive to getting somewhere where you can be successful. So those are the things you do not want to be doing. Here's what you do want to be doing. The first thing is you want to make sure that you have either like a stack of like plain white paper, or like a notebook, or anything where you can jot down. It could be a legal pad. It could be whatever. It could be those little trial notebooks that I'm preparing for everybody. And you want to have that and a pencil or a piece of paper there. And what you want to be doing, and this in particular, this might not be as relevant whenever it's the attorneys arguing or whenever it's like the judge talking or something like that. But whenever there's a witness talking, you want to be keeping track of a few different things. Okay. The first thing that you want to be keeping track of is you want to be jotting down, number one, anything that you can rebut. Okay. So anything that witness is saying that either you can rebut or you have a witness that can rebut. And by rebutting, basically what I mean is for you to testify to the opposite. Okay. Or the witness to testify to the opposite. You want to jot that down. Okay. And it's probably smart that before you go into the hearing, you tell your attorney, hey, listen, this is what I'm going to be doing. If you want me to be doing something else, that's fine, but I'm going to be doing this. And then that way you can like kind of glance over and look at what I'm writing down. It'd be helpful. The second thing that you want to do is you want to write down anything that the person is testifying to, especially when it's a cross-examination situation, anything that they're testifying to that's a lie. Okay. So anything that they're testifying to is a lie. Make sure you jot that down. And then the third thing, which is a follow-up on that, is anything that is a lie, or even in number one, anything that can be rebutted, you want to jot down either a testimonial piece of evidence or a physical piece of evidence that proves that lie or allows you to rebut that, if that makes sense. So if it's a testimony that you'll just be able to rebut yourself, that's obviously easy. You could just like not note there that your testimony will fix that. But if your mom or someone, if they're testifying to something where your mom, they're an incident that happened where your mom was present, and your mom can testify and say that they're full of shit, then you can write down like mom's testimony. Does that make sense? Or if they're testifying something that they notified you of something, or that they responded to something in some way, and then you have screenshots of an email or text message or something like that, you can make that note. Okay. Text message, blank date, whatever. Okay. And then if there's ever like a break or anything during the testimony, then you can do like subtle, like I always tell my clients, like, hey, if there's like a break in the testimony or something and you need my attention or you want me to look at something, just like either give me like a subtle bump, like a subtle elbow bump or leg bump, or slide that like piece of paper over to me. You know what I mean? Like kind of like back when you were in school and you kind of slide it over to let them look at it. Because what that does is it does a couple things. It lets you keep track of what's going on. It lets you feel like you're participating in the case. I lost Jason. It lets you feel like you're participating in the case, and it allows you to contribute in a way that's going to help your attorney most effectively. And if your attorney knows what they're doing, which they probably do, they're going to appreciate this immensely. Okay. And I can't tell you how important that is, because the last thing that you want when you're a lawyer trying to really effectively represent someone, you can't be distracted. But you guys also as clients have a lot to add. So this is the best way to be able to balance it so that you can add your significance, because obviously you're the freaking parent, for God's sakes. Like you're kind of significant in the case. You kind of have a lot to add, so you can add that, but also you can step aside to let your attorney do their job, if that makes sense. Okay. So that's number one. The ultimate no-nos, like I said, other than interrupting your attorney all the time, you don't want to ever do anything that's audible for the judge, especially. Right? You don't want to do any like, oh shit, or like, and I talk about that in the I might even mention that in the webinar a little bit, but those huffs and eye rolls or laughs, like nervous laughs when someone's on the stand lying and you can't believe that the words are coming out of their mouth, and you do the nervous laugh thing, that's not going to get you any points. Don't do any of that kind of stuff. And I think that's really it from Counsel Table. I think those are the main do's and don'ts from Counsel Table.